And we will make sure we get that answer. The gentleman from Oregon, Mr. Benz.
Thank you, Mr. Chair, and thank all of you for being here today. So my question is, I'm not sure which one of you to ask, but the issue is whether our technology is such that we can actually do what I think many of you want us to do. And I'm just thinking of the Led Zeppelin situation that took years to sort out whether or not, quote, the descending chord sequence had been used for centuries and whether or not it had been stolen. And of course, it ultimately was decided after 5 or 6 or 7 or 8 years of litigation that Led Zeppelin had, for various reasons, not usurped it. My question to you is, and I'm going to ask it of you, Mr. Navarro, if you think that we have the technology available to sort these things out after the fact, and if not, what would you be suggesting that we do to try to prevent it before it happens? I just want to know, given the nature of music, and I'm a very bad musician, but I know what a guitar is, how in the world do you sort this out? Do we have the technology available?
I'm not sure we're qualified to determine how it's sorted out. I know that I, as a creator, if I get too close to something, I pull back. If I get a little too close to Ray Charles, I pull back. If I get too close to John Lennon, I pull back. And if I don't do it right, there are legal remedies. Just ask George Harrison or Robin Thicke.
Mr. Damley, I'm not sure I pronounced your name correctly, but could you address the question?
Thank you, Congressman. You got it exactly right. So I would point to the sort of cases that you're talking about, like the Led Zeppelin case, like the Blurred Lines case, as examples of instances where copyright did not stay within its proper bounds, where courts decided that borrowing somebody's musical style counted as copyright infringement. And I think when those decisions came down, it really threw the music industry into chaos. I'm a music lawyer in addition to being a technology lawyer. I know that the music industry really grappled with those decisions, and you had artists saying that they were afraid to create because they were worried that they were inadvertently, perhaps, borrowing the style from somebody else. And it got to the point that even the rights owner groups started criticizing those decisions, saying they went too far. They did not allow artists to express themselves as freely as they should be able to. And I think, thankfully, we've seen a return back to those core principles of the Copyright Act, which is ideas, styles should be able to be used by all. So that's what we've seen in these recent decisions involving Ed Sheeran, a return back to that principle of being faithful to the Copyright Act, faithful to the Constitution's mandate for what the Copyright Act is supposed to do. And so that would be my response to that issue.
And thank you for your answers. And with that, Mr. Chair, I yield the rest of my time to you.
I thank the gentleman for yielding.